Hello and welcome to our video presentation. Today, we shall be focusing on duress from both the aspect of English and Malaysian law, as well as comparing and contrasting the respective approaches of both sides of law towards duress as a vitiating factor. Before we start, I would like to briefly touch upon the topic of the formation of contract. As shown in the slide, the ingredients required to form a contract includes an agreement, which involves both offer and acceptance, consideration, and the intention to create legal relations. However, even after fulfilling all the elements mentioned above, the process of coming into an agreement is vital. Therefore, we have to look at whether factors such as duress or fraud took place during the procedure, as the presence of these vitiating factors may destroy or impair the legal effect of a contract. Before we can start comparing, it's important for us to familiarize ourselves with the law of duress from both sides of the law. And we will now begin with the law of duress in the UK.
According to Lord Nichols, in the case of Royal Banks of Scotland and Ipswich, people tend to constantly influence the decisions of others in their daily lives, mostly for their own benefits. They seek to persuade those with whom they are dealing to enter into transaction, whether great or small. But how far should the persuasion be for it to be labelled as duress? Well, the English law has set limits to the means properly employable for this purpose. Assent to the terms of a contract cannot be deemed voluntary if one party is forced into the agreement by way of threats, blackmails, or extortions, as it constitutes as duress, and recognizing this, the courts allowed for the innocent party to either use duress as a defense to the enforcement of a contract or a ground for rescission of a contract. Therefore, the innocent party can choose either to carry out the contract terms or avoid the entire transaction altogether. The principal difficulty is that duress does not deprive a person of all choices but merely presents him with a choice between evils. There is in fact no simple factual test of whether the person claiming duress has ceased to act voluntarily, but there has to be consideration of whether the decision was made in an unacceptable circumstance. One factor affecting to the existence of duress is the overbond of will, which focuses more on the lack of reasonable alternatives other than agreeing to the agreement from the victim's standpoint. Other than that, the law also looks at the illegitimacy of the threats where the guilty party's action or behaviors are taken into account. There are three forms of duress, namely duress of person, duress of goods, and also economic duress. Duress of person arises when there are threats or actual violence or threats of imprisonment, although the latter rule arose only after the intervention of equity. As such, the doctrine was of little significance, since the numbers of cases of duress to the person had always been small. Let's look at the cases for the duress of person. The case of Barton and Armstrong illustrates that when there are threats made to a person resulting to his signing of a deed, the contract may be set aside even if he might have entered the contract in the absence of duress. The principle laid out in this case was that a causal link must be shown where the innocent party has to establish the relationship between the illegitimate means used and the action taken, and it does not need to be the only cause of the entry to the contract. Ashley and Reynolds created a new ground under duress by way of duress of goods. Before this case, duress of a person was the only form of duress recognized as deserving of a legal redress, as threats in relation to goods are insufficient to render an agreement voidable. One lesser form of duress that gave rise to a body of modern case laws is where the threat is economic. English law now accepts that the equitable remedies of rescission will be available for certain kinds of economic duress, such as in the case of Pound-on and Lau Yew Long. It was held that ordinary commercial pressure cannot amount to duress, as duress is the coercion of the will that vitiates consent. Lord Scarman said that in determining whether there was a coercion of the will such that there was no consent, it is the material whether the person alleged to have been coerced did or did not protest, whether they had alternative causes open to them, such as an adequate legal remedy, whether they were independently advised, and whether they took steps to avoid that said contract. However, in a more recent case of Atlas Express Limited and Calfcore, there was an issue of whether a new agreement can be voidable on the ground of economic duress, and it was held that mere commercial pressure is not the coercion of will and not sufficient to amount to duress. A distinction between the two will always be hard to draw and may depend upon a close examination of the facts of the particular case.
Moving on, we'll now look at the Malaysian law of duress. The Malaysian law recognizes that there are certain forms of pressure that may be applied on parties which do not amount to physical threats, nor to a person, nor to the damage of goods, but which may allow the innocent parties to render a contract voidable. This kind of pressure is normally applied when a contract already exists in order to obtain better terms. The requirement of free consent is essential for an agreement to become a valid contract. Under Section 14 of the Contracts Act 1950, consent must be free and not instigated by coercion. If the consent given was not a free consent, a contract can still come into existence but is voidable at the option of the innocent party, as there should always be meeting of minds when it comes to the making of an agreement. According to Section 15 of the Contracts Act 1950, coercion is defined as the committing or threatening to commit any act forbidden by the Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. The Penal Code also has provision concerning coercion, as in Section 19. It allows for a contract to be voidable at the option of the party whose consent was not free. And Section 2(1) states that only parties whose consent was not free have the right to render the contract voidable. The following are the elements that make up coercion. The first is the presence of a coercive act, and that means that the accused party must have committed or threatened to commit any act which is forbidden by the Penal Code, or unlawfully detained or threatened to detain any property. The next element that we have to consider is the effect of that particular act of coercion. The coercion must be to the prejudice of any person, prejudice here meaning some form of detriment. It's also important to take into consideration the intention or the mental state of one who is exercising such coercion to force the person to enter into an agreement. And lastly, the innocent party must have entered into the agreement due to a coercion, the coercion being one of the cause and not the only causation. There's a need to take note that Section 15 of the Contracts Act 1950 does not state that the person committing the coercive act must be a party to the agreement. Third-party coercion may also render an agreement voidable. Following the wording of the statute in the Contracts Act 1950, it is noticeable that, unlike English law, not much has been said about economic duress, and that is because it is not expressly stated in Section 15 of the Contracts Act, as the definition of coercion is very limited, and the High Court held in the case of Perlis Plantation, Berhad and Muhammad Abdullah Ang, it says that the Contracts Act 1950 does not provide for other forms of coercion other than as defined by Section 15. The principle of economic duress was tacitly recognized in the case of Teck-Guan Trading and Hydrotech Engineering 1996. The court held that there was no coercion in this case, as there was neither a penal code offence nor unlawful detention of property. Also, there was no economic duress as this was a transaction in the ordinary course of business. In the case of Zainul Abidin B. Mohammed and Lee Lim Huat 2015, the court held that although Section 15 does not provide for duress as a defense, in Malaysia, the concept of duress and that of coercion have been used interchangeably. And with that particular statement, we can assume that the courts in Malaysia do recognize the possibility of economic duress, even though it is not expressly stated in the statute. There are several remedies the courts allowed following the statutes provided below. Section 65 of the Contracts Act 1950 provides that the other party, namely the innocent party, can be excused from further performance. The receding party should also restore any benefits received under voidable contract. Section 66 of the Contracts Act 1950 states that the party receiving advantage under the contract must restore any advantages received or to make compensation when the contract is deemed to be void. Section 76 states that the rescinding party is entitled to be compensated for any damages sustained through non-fulfillment contract. Coercion in Section 73 has a wider meaning than in Section 15, as it says that a person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. In Chim Nam B Development, Sendian Berhad and Thai Kim Chu 1988, the court allowed for the recovery of sum paid under coercion even though the provision of Section 15 of the Contracts Act 1950 were not satisfied.
Only after discussing both sides of the law can we finally move on to the comparison of the law of duress from the two different states. To reiterate, under the English law, we can understand that the term of duress applies when one party has been induced into a contract by another through the means of illegitimate pressure of some kind, and that there are three different forms of duress, namely duress of person, duress of goods, and economic duress, whereas the Malaysian law, coercion, is looked at and is defined as the committing or threatening to commit any act forbidden by the penal code or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. We will first discuss the differences and similarities in the law of duress of each classification before delving into the advantages and disadvantages of law of duress of both of the common and Malaysian law. The biggest difference between Malaysian law of duress and the common law of duress perhaps is that Malaysian law has a statutory provision which expressly provides for what the coercion is, whereas the common law till today relies only on the cases. English common law stated in the case of R and Shayla that apart from threats against the person himself, members of the accused's immediate family or the people whom the accused reasonably consider himself as responsible for their safety are also put into an account. However, Section 94 of the Malaysian Penal Code states that if a person is compelled to do something by threats and at the time of doing it cause the apprehension that if he does not, death would be the consequence and that he did not act of his own accord, is not considered as an offence. This shows that Malaysian law only allows the threat to be directed to the accused himself, and outsiders such as the third party could not in fact sue on the behalf of the victim. Besides this point, there are no other differences as there are very little cases for duress of person in both sides of the law. There are, however, variances in both the common law and Malaysian law of duress of goods. Duress to goods under the English common law is slightly narrow as compared to the definition of coercion provided under Section 15 of the Contracts Act 1950 in the Malaysian law.
The reason why coercion under Section 15 has a broader meaning is because it covers unlawful detention of property and expressly recognizes duress of goods. The current position of duress of goods under the common law, on the other hand, is the principle laid down in the Seaborn and Seaborn Chair and upheld by Area Law that only threats made in relation to good may render a contract voidable. Economic duress in the common law arises when one party uses his superior economic power in an illegitimate manner so as to coerce the other contracting parties to agree to a particular set of terms. But there is an issue in the Malaysian law of whether Section 15 of Contracts Act 1950 covers economic duress, as the definition of coercion in Section 15 is very limited, although some authorities later appear to recognize the doctrine of economic duress in principle. Besides that, both the common law and Malaysian law have different remedies when it comes to duress. In the English law, the only remedy available for the victim of duress is rescission of the contract and consequential restitution. Damages are not available for duress even where the contract is not rescinded, although in such situation, the innocent party may raise duress as a defense. This is seen in the case of the Atlantic Baron case, where the plaintiff was given the opportunity to consider economic duress. As for Malaysian law, there are several effects of rescission under the penal code, such as the other party being excused from further performance and the rescinding party must restore any benefit received under voidable contract, or that any party who receives any advantage under the contract must restore any advantage received or make compensation.
The differences of duress in both aspects of English and Malaysian law are more compared to the similarity, but now I will begin explaining about the common components that both of them share. There are two general similarities which I am going to highlight in our presentation between both sides of duress. The first being that duress must cause the innocent parties to enter into the contract. And the next is that both Malaysian law and common law offer the same equitable remedy of rescission, meaning that the innocent party can render the contract voidable. The other similarities in the English and Malaysian law of duress is the emphasis on the term instant and imminent. In the Malaysian case of Tan Seng An and PP, the learned judge mentioned that only the fear of intermediate death would be a sufficient justification. Meanwhile, in the case of M. Grothus, 1746, the courts also stated that in order for a case to be pled successfully, duress must be imminent, extreme, and persistent. The case of OCBC Securities, Melaka Sdn Bhd and Koh Kee Huat, 2004 affirms that it has been observed that although the Contracts Act 1950 provision on coercion does not specifically provide for duress as a defense in Malaysia, the concept of duress and that of coercion have been used interchangeably in the courts of Malaysia. The court further held that to import the concept of economic duress, one must satisfy the guidelines given by the Privy Council in Pawan and Lau Yu Long, 1980, which have already been mentioned earlier. The remedy provided for duress, which is mainly rescission of contract and reinforcement of the agreement by the innocent party, is an advantage by itself. There are, however, a few disadvantages and criticisms made with regards to the remedies of the law of duress. With these resemblances, the law of duress is said to be a necessity in today's law, despite the narrow defense it provides. The common law allows for only two types of defense, mainly an excusatory and a justificatory one. However, the necessity of duress only applies in exceptional circumstances where there are restricted choices made available to the victims. On a number of further occasions, however, the English courts have refused to recognize a general defense of necessity. For example, Lord Denning in Southwark
London Borough and Williams, 1971, expressed the view that hunger could never excuse theft, and neither in a civil context could homelessness excuse trespass. He said, if homelessness was once admitted as a defense to trespass, no one's house could be safe. Necessity would open a door that no one could shut. It would not only be those in extreme need who would enter. There would be others who would imagine they were in need, or would invent a need so as to gain entry. In this statement made by him, Lord Denning tells us that although hunger and homelessness may constitute as duress, the law cannot take into account these forms of duress to justify theft and trespass, as it would lead to floodgates. Both the Malaysian and English law of duress have been criticized by their own respective scholars, although there are more articles which highlights the doubt of the English law of duress. It has been proposed that there are underdevelopments of the doctrine of duress of goods, as the courts more often hold duress of person on a higher ground as compared to duress of goods. The law concerning the duress of person have been criticized as well, as scholars recognize that when a person is under immediate threats, they will have to seek immediate help instead of seeking help from the courts. Instant relief is required, and there is frankly no time to seek protection from the law. Besides that, the issue of conclusive judgment between parties was brought up as well in a Cambridge article, and that usually money paid voluntarily for something in return cannot be recovered. As for the Malaysian law, Mariam Rafiee states that the Contract Act 1950 does not apply to online environment, which in the current age is inevitable. For example, when a person wants to access a website online, a terms and conditions column will usually appear, and the person is forced into agreeing if he wants to access to that particular website. There is absolutely no room for negotiation of the terms put forward.
After Ihan has clarified the similarities and the ups and downs of the law of duress in both states, I shall now continue with the criticisms of this doctrine by the respective scholars in both English and Malaysian law. In the case of Attorney General N. Whelan, 1934, an obiter dicta illustrated that the defense of duress cannot be applied to murder cases, as the commission of murder is believed to be a crime so heinous that it should not be committed even for the price of life, and in such a case, the strongest duress would not be any justification. This has raised many arguments solely because it concerns the sanctity of human lives. A balance between the seriousness of threats and offences must be achieved. Lord Bingham, in the leading case of R. and Hassan 2005, provided some elements that are prerequisite for the defense of duress, which includes specific crimes and immediate threats. According to Noor Ertina Ahmad Sharif, English law can be said to be more concerned with the process of making a contract, whilst Malaysian law focuses more on the substance of contract. She relayed in her articles that the doctrine of duress, undue influence, fraud, and misrepresentation are all examples of procedural unfairness, whereas prohibition of certain contract terms, such as restraining trade, revolves around the substantive aspect of contractual fairness, and the English law are generally not concerned with the substantive aspects of contractual fairness. In a nutshell, the doctrine of duress has a wide and vital role to play in the regulation of legal relationships. The kind of coercion used and the acts expected of the coerced party, which are said to be the consequences of the coercive act, should be disregarded in Jack Bitson's opinion in the Cambridge Law Journal. He perceived that there are no reasons to make a distinction between the different types of duress because, as long as threats are present, it does not matter whether it is towards the person or the goods. It did indeed constitute as a form of intimidation which eventually leads to duress. In theory, the law of duress by threats is hugely advantageous and essential for innocent parties forced into committing a crime or entering a contract. Or, in general,
doing something against their will. However, the defenses of duress are still uncertain and inconsistent at some point, as the courts are still looking into it when it comes to severe circumstances. Nevertheless, when one looks at the law of duress as a big picture, it is substantive as a vitiating factor in contracts in both sides of the law.
That is all for our presentation of the law of duress.
Thank you for watching.